submitted in this case. Regarding the pending motions regarding our petition. I'm not going to go over all that. I wouldn't have time to do so, but I do want to try and present an overview of our position. More than a summary recitation of the contents of the briefs, which I know you have or will review. Objectors' challenge is based, as I said, on the fact that candidate Trump's mandatory certification under the Illinois Election Code that he is fully qualified to serve as president, while submitted, is false. Accordingly, as a matter of both the Illinois Election Code and Constitution, he may not be placed on the ballot for the Illinois Republican primary or presidential preference election scheduled to take place in March 19th. Candidate Trump is not qualified to run for or serve as President of the United States under Section 3 of the 14th Amendment to the Constitution because when he previously served in the office of presidency, having sworn an oath to support the Constitution, he encouraged and engaged in numerous efforts to prevent the peaceful transfer of power, the certification of the outcome of the 2020 presidential election, which he lost to now President Joe Biden. He unquestionably fostered, encouraged, and engaged in the insurrection that took place in Washington, D.C., and in particular at the Capitol on January 6th. He summoned the crowd to Washington for what he promised would be a wild event. He contributed money and helped plan the critical mustering event at the Ellipse Park outside the White House, from where the crowd marched, attacked, and seized the United States Capitol. He incited the crowd into a frenzy against the Vice President of the United States, members of Congress, and in support of Mr. Trump's own stated goal of stopping the process of counting the electoral votes. He directed the crowd to the Capitol after the rally at the Ellipse, where they brutally attacked the police. They overran the Capitol. They threatened to and nearly got close enough to assassinate the Vice President and other government officials. And by means of this violent, armed invasion, Mr. Trump achieved his goal of disrupting and at least significantly delaying the constitutionally mandated electoral vote count that would, and ultimately did, certify Joe Biden as the winner of the election. In so doing, Mr. Trump engaged in an insurrection that obstructed the functioning of Congress as mandated by our Constitution. For the first time in our nation's history, peaceful transfer of power was disrupted. In short, he engaged in what the Constitution refers to as an insurrection against the Constitution in violation of Section 3. Insurrection, that term, has been widely held and understood to mean both during the Reconstruction era, when the 14th Amendment was enacted following the Civil War, and in more recent times, as the concerted use of force or violence, or both, as here, to resist the government's authority to execute the law. That, sir, is exactly what happened in January. An insurrection is not a mere protest, or even an act of civil disobedience, but rather, as here, it is the concerted use of force and or violence to resist the government's authority to execute. Here, the law in question was nothing less than the constitutionally mandated process for the peaceful transfer of presidential power, one of the most essential elements of our democracy. There is no real dispute as to whether the violent storming and seizure of the Capitol on January 6, 2021 was an insurrection. The tragic events of that day have been recognized as an insurrection by both parties, in both houses of Congress, in numerous court decisions, and indeed admitted by the candidate himself by counsel during his impeachment proceedings in the United States House. The term engage in this context means simply its common meaning: voluntary assistance by service or contribution. You need not carry a weapon, not have any particular act of misconduct. You must simply voluntarily aid by service or contribution. We submit, sir, there is no reasonable construction of the undisputed record other than that Mr. Trump provided voluntary assistance to the insurrection. He did so by instigation. He did so by providing material assistance. He did so by making public encouragement repeatedly. He did so by his efforts to prevent weapon detection so that the crowd could march armed to the United States Capitol. He did so by his failure to order federal police or the National Guard involvement. He did so by urging the assault on the Capitol. And he did so by refusing to halt for over 3 hours while watching it unfold. Before you, Judge Erickson, are the objector's motion for summary judgment or judgment on the record, as well as the candidate's motion to dismiss the objection. As I had mentioned, these motions have all been extensively in record time. So I will only address them briefly in a few minutes. But first, we want to provide a visual context to our remarks. We would like to play a brief video of the events that occurred on January 6th at the insurrection. This video was prepared by the House of Representatives January 6th Investigative Committee. We have made 2 changes to it. We have inserted a tweet from Donald Trump at one point, which will be apparent, and we have removed a short clip of someone in the crowd shouting into a bullhorn because we have some question as to the accuracy of the timestamp of that clip. We have no concern about the substance of the clip. If the court would like to see it, we were happy to show it to you, but we were concerned that potentially there may be a timestamp inaccuracy for that reason. And we put the video.
Counsel. Your Honor, if I may ask procedurally, so there are certain objections that have been made, including this video. Do you want us to articulate those right now as the video comes up, or do you want us to wait for argument? I want to be respectful of your preferences for the procedure here.
Well, I think you can articulate them now.
Certainly, if this is the one I believe it is. This is from the January 6th committee report. We have a lot of objections about that committee. These are highly curated and edited videos. With respect to the timestamp issue with the person in the megaphone, we had a witness who provided an affidavit and he contested actually the content and the proper timing of that. So this is one of these videos where I think it's more akin to a movie production than it is a actual authenticated, this is what I saw happen in the Capitol. There were hundreds, or near the Capitol, at the ellipse, or perhaps in the Capitol, there were hundreds of thousands of people who attended. So again, this is a very highly curated, very focused and narrow perspective that we objected to on the authenticity of this, as well as the admissibility. We've recognized the authenticity of a number of videos. This is not one of them.
What is this exhibit number?
We don't offer it into evidence as an exhibit. We did offer the Colorado transcript, and I'm using this as a demonstrative during my.
All right, that's fine. Does that complete your objections?
Unless you have other questions.
Yeah. No, I'm fine. Okay. I'm going to. We'll note the objection, and I'm going to allow the video to be played.
Something you know is that these kids of the right.
Proud of your boy! Proud of your boy!
Yeah, just for awareness, be advised, there's probably about 300 Proud Boys. They're marching eastbound in this 400 block of kind of Independence, actually on the mall towards the United States Capitol.
I am not allowed to say what's going to happen today because everyone's just gonna have to watch for themselves. But it's gonna happen. Something's gonna happen.
He can go against you. Understand the side. Pick a side. These are our streets.
I hope Mike is going to do the right thing. I hope so. Because if Mike Pence does the right thing, we win the election. All Vice President Pence has to do is send it back to the states to recertify. And we become president, and you are the happiest people. Mike Pence is going to have to come through for us. And if he doesn't, that will be a sad day for our country. Because you'll never take back our country with weakness. You have to show strength and you have to be strong.
Cruiser 50, it does look like we're going to have an ad hoc march stepping off here. There's a crowd surge heading east.
We love Trump. 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 We love Trump.
Mike Pence, I hope you're going to stand up for the good of our Constitution and for the good of our country. And if you're not, I'm going to be very disappointed in you. I will tell you right now.
Get back, ladies. Get back, ladies.
Senate controls the call your station. We just had protest. Speed circle, breach the line. We need backup.
Madam Speaker, the Vice President and the United States Senate.
We're going to give riot warning. The CCI route is here. We're going to give riot warning. We're going to try to get compliance, but this is now effectively a riot.
49 hours declaring it a riot.
325 to 50, be advised, Capitol Police 1 advised they're trying to breach and get to the Capitol.
Yeah, copy. We're about 5 miles out. We're trying to make our way through all this. We have a breach of the Capitol. Breach of the Capitol to the upper level.
Be advised, they're requesting additional resources on the east side as they've broken into that window and they're trying to kick it in.
Without objection, the chair declares the House in recess pursuant to Clause 12B of Rule 1.
Bring out Pence. Bring out Pence. Bring out Pence.
We can't hold this. We're gonna get too many fucking people. Look at this fucking vantage point, man. We're fucked.
We need an area for the housing members. They're all walking over now through the tunnels. We're trying to hold the upper deck. We're trying to hold the upper deck now. We need to hold the doors of the counter. I need court support. We lost the line. We lost the line. All NPDs get back. All NPDs get back up to the upper deck. All NPDs get back to the upper deck. ASAP.
Cruiser 50, be advised that Capitol Police is going to start moving their resources inside. They're going to start the M4 officers first.
Okay, H208 with 4 members. The door's barricaded. There's people flooded the hallways outside. We have no way out.
In fact, officers still remaining on the house floor, on the third floor, to use the subway themselves. It's time to evacuate so we can secure the members on the other side. Copy.
It's up to us people now, the American people. What are you ready to do? One more time. What are you ready to do? And whatever it takes, I'll lay my life down if it takes. Absolutely. That's why we showed up today. Hey,
You back up.
I have myself on back. We can stay from some of that West Carolina for backups.
People, these were great people. The crowd was unbelievable. And I mentioned the word love, the love in the air. I've never seen anything like it.
That concludes the video.
Okay, yeah, for the record, the video is.
Judge,
I'm
this is
sorry, Your
not-
Honor, did you say the video's been admitted?
No, completed,
Completed.
finished.
Judge, this
My
is
ears
not.
connected.
I'm sorry. Counsel? One.
Do you want me to, Your Honor, renew or amplify our objection or wait until our argument to discuss it?
Maybe it's best to wait till you're done. Thank you.
This was not, sir, as some have said, a legitimate protest. Not tourists. This wasn't just another riot in one of America's cities, which we have unfortunately experienced. Regardless of political perspectives and regardless of allegiances, it is undeniable, at least we hope it's undeniable, that the storming of the seat of our democracy by thousands of violent attackers in an effort to block the peaceful transfer of power is a stain on the history of our nation, which must be rejected in the strongest possible way. Stop for a minute and think what your reaction would be if this attack was directed on your home. And consider that it was exactly that. For in our republic, the Congress is the governmental home of the people. All of us, as provided for in the Constitution. Still, the candidate has repeatedly failed to denounce what happened from January 6th. And indeed has recently referred to those persons thus far convicted of their criminal misconduct on that day as hostages. This proceeding, he does not appear to try to defend his role in the violence of January 6th. He has chosen not to defend his conduct even by affidavit. Rather, the candidate asserts that the extensive evidence presented by the objectors either does not state a proper legal objection and or does not establish to a preponderance of the evidence that the candidate engaged in an insurrection in violation of the Constitution. That is incorrect, as we have explained in the very thorough briefs. Again, I don't want to summarize those briefs or read them to you, but very briefly, a few observations about the pending motions I think are. As an initial matter, the candidate has filed a motion to dismiss our objection, which fails for want of any significant legal support for any of its arguments. Candidate's primary argument in support of dismissal of these proceedings is that the state board lacks legal authority or ability or both to resolve the pending objection because it is too complicated. There is no complicated proceedings exception that we've been able to find in the Illinois Election Code. Not only does the board have full authority, as well as repeatedly proven ability over the years to handle very complex matters, it has clear statutory mandate that it must do so and do so expeditiously. The reply that was filed late last night, the candidate argues again wrongly that the Illinois Election Code somehow limits the board's authority to determine only the form, timing, genuineness, and accuracy of nominating papers. I suppose the term accuracy is a bit vague, but the Illinois Supreme Court precedent that discusses the pertinent scope of the board's authority could hardly be much clearer. It is, I know, proudly in a case that we won in front of the Illinois Supreme Court. The Supreme Court in pertinent part ruled the statutory requirements governing statements of candidacy and oaths are mandatory. If a candidate's statement of candidacy does not substantially comply with the statute, the candidate is not entitled to have his or her name appear on the primary ballot. Though Ward, one of the parties in that case, did sign the statutorily required statement of candidacy and submit it with his nomination papers in the case before us, the statement did not satisfy statutory requirements. As we have discussed, his representation that, quote, I am legally qualified to hold the office of Circuit Court Judge, 12th District, 4th Judicial Subdistrict, end of quote, was untrue. That's a subquote within the quote from the Supreme Court, was untrue. Ward did not meet the qualifications for office. The court held that the objection should have been sustained because the candidate did not meet the requirements set out in the Illinois Constitution. That is Goodman v. Ward at 241 Illinois 2nd 398, Penn site 409-410. It's a 2011 decision that is cited in numerous papers. Quite simply, binding Illinois Supreme Court precedent requires the electoral board to consider objections based on constitutional candidacy. There is also, with regard to the motion to dismiss, no serious question that we have properly pled a violation of Section 3. But in addition, as we address our summary judgment motion and our motion on the record, we've proven as well. Remaining arguments in the motion to dismiss, some of which were reiterated late yesterday in the reply brief, are even more insubstantial. There is Trump's absurd argument that he never swore an oath to support the Constitution. We can agree that he did not, in fact, support the Constitution, but he certainly swore to do so nonetheless. His attempt to draw a distinction in this regard between the language of the presidential oath to, quote, preserve, protect, and defend, and Section 3's language of, quote, unquote, support, is one that, Your Honor, not even a lawyer's mother could. As explained in the briefs, there is absolutely no basis to believe that Congress, enacting this provision, the 14th Amendment, under the troubled presidency of Andrew Johnson, without any suggestion during the debate of the 14th Amendment that somehow the office of the presidency was excluded from its coverage, no basis in the record to find that they intended to allow only the president of all the federal officers to commit treason and get away with it and be able to run it. Section 3, like the rest of the 14th Amendment, is self-executing. That is to say, it requires no order of court or act of Congress in order to be the law that must be obeyed. That is clear in numerous case decisions, but it's also clear from the language of Section 3 itself. It imposes a disqualification from office, which can only be lifted on its terms by a supermajority vote of the United States Congress, 60% vote of the United States Congress. In other words, an action that is required, as provided for Section 3, isn't to implement, it's to remove its disqualification. There could hardly be a more paradigmatic example of self-executing provision than Section 3 of the 14th Amendment. After the Civil War, it's worth noting, Congress lifted the disqualification of Article 3 from federal office being sought by from many, but certainly not all, of the supporters of the Confederacy. They did so with the required 60%. Those, in the statute in question is called the Amnesty Act of 1872. Those who were subject to the Amnesty Act had prior to the act been subject to the disqualification. Otherwise, of course, no need for the Amnesty Act. And they were so disqualified without any judicial determination or act of Congress. It was self-executing. So the best proof of the intent is how it was applied at the time of its enactment. And here it is clear that there is no subsequent action required to trigger the disqualification under Section 3. The constitutional provision was that it is now self-executing. And not only, as I know, does the board have full authority and proven ability to handle complex matters, correct? Both in the statute and by the Illinois Supreme Court case that I just cited to you. In short, there's no question that we have properly pled a violation of section. And by the way, I should note, although I think it's obvious, that Congress has never by supermajority or otherwise voted to exclude Donald Trump from the disqualification contained in section. Candidates' remaining arguments in the motion to dismiss about the political question doctrine ignore the fact that this doctrine is only applicable to matters which are textually committed by the Constitution to be more legislative in nature than judicial, and when such matters cannot be adequately managed or the outcomes properly determined by a court. There is no such constitutional commitment to the legislature here or difficulty of application here. The candidate extensively argues the obvious political nature of this case. It is about a candidate running for elected office, running in the primary election, then running for elected office. It is about the political process, as indeed is almost everything that the state board of elections does. That doesn't mean that it all becomes a political question that is non-justicial. If that were true, then all of the 40 or so lawsuits that candidate Trump brought after his failed presidential election, and actually before he voted in some cases, I think, about improprieties in the election process, they all would have been dismissed as political question cases. They weren't. They were instead dismissed on merits. Objector has presented motions for summary judgment or judgment on the record. And we submit, sir, that the factual record provided establishes the following material and undeniable facts, not only to a preponderance of the evidence, but indeed beyond any reasonable doubt. We don't think there's any doubt or controversy about any of this. These facts alone, although only a small part of a much richer factual record that we have submitted, Your Honor, and burdened your clerk with, I'm afraid. But you don't have to go any further than these. The rule in our favor that the candidate is disqualified under Section 3 of the 14th Amendment. First fact, undisputed, the candidate Donald Trump took an oath to uphold the United States Constitution on January 20, 2017. We don't think this fact is disputed, but to the extent it is, you may take judicial notice of it. And indeed, you may take judicial notice of, I think, every fact we're about to articulate. Fact number 2, the candidate, Mr. Trump, ran for re-election in 2020, and he lost that election. 3, before the election was even held, the candidate stated repeatedly, the only way he could possibly lose the election was if there was the product of voter fraud during the election. 4, after he lost the election, the candidate repeatedly exhorted his followers on Twitter and elsewhere that he had in fact won the election and that they should take action to, quote, stop the fraud and, quote, stop the count of the votes as cast by ballot, as well as by the presidential electors' vote count. On December 14, this is fact number 5, I'm sorry. On December 14, 2020, presidential electors convened in all 50 states in the District of Columbia to cast their official electoral votes. They voted 306-232 for Joe Biden and against Donald Trump. 6, thereafter, after this vote, Mr. Trump continued to dispute the election results, claiming that they were the result of fraud, and he urged his supporters to take action to dispute the results. 7, certification of the electoral votes by Congress is scheduled to take place on January 6, 2020. 8, on December 19, 2020, in anticipation of that certification on December 19, 20, the year before 2019, in anticipation of the January 2020 vote, 2021, I've got my years wrong. Everybody knows what year this happened, except me. On December 19, 2020, Trump tweeted his supporters, quote, big protest in DC on January 6th. Be there. Will be wild, close quote. In response to this call, thousands of Mr. Trump supporters prepared to and did come to the District of Columbia for the January 6th protest of the certification of the electorate. And among those who came to DC in response to Mr. Trump's call for a wild protest were armed and militant supporters, including members of the extremist organizations known as the Proud Boys, the 3 Percenters, and the Oath Keepers. On January 6th, seen in the video, and we all know, there was a large rally on the Ellipse Park immediately south of the White House. Speakers at that rally were approved by Mr. Trump and included Mr. Trump. Speakers, many of the speakers at the rally engaged in incendiary rhetoric. Rudy Giuliani, who was at the time one of Mr. Trump's election lawyers, called for the crowd to engage in what he characterized as, quote, trial by combat. Representative Mo Brooks from Alabama urged the crowd in his speech to, quote, start taking down names and kicking ass, close quote, and to be prepared to sacrifice their, quote, blood, close quote, and their, quote, lives, close quote, and, quote, do what it takes to fight for America by, quote, carrying the message to Capitol Hill because the fight begins today. During Mr. Trump's speech at the Ellipse, number 13, he told the crowd, quote, we fight like hell. And if you don't fight like hell, you're not going to have a country. Mr. Trump's speech, he also repeatedly focused on Vice President Mike Pence, who, as we know, had refused Trump's request to unilaterally reject the valid electoral results from the states that Trump lost and to send them back to the state legislatures in the hope that the legislatures would appoint then pre-Trump electors and the outcome of the electoral college vote would be different. Mr. Pence, his lawyer, and the United States Department of Justice had repeatedly informed Mr. Trump prior to January 6th that the vice president had no legal authority to do any such thing. Trump then instructed the crowd at the end of his talk to march on the Capitol, where Congress was at that moment convening to certify the electoral votes. Let's count him at 16, but thousands of Trump supporters marched on the Capitol, overwhelmed the police security officers, stormed and seized control of the building. The seizure of the United States Capitol was recognized as an insurrection in sadly very rare bipartisan measures in both the United States Senate and the House. It has been so recognized by numerous federal courts, and as I've mentioned previously, by Mr. Trump himself during his impeachment proceedings, albeit by his authorized agent, his counsel in those proceedings, not out of his own. Many of these insurrectionists shared the common purpose, preventing Congress from certifying the election. Some of them also expressed a desire to assassinate Vice President Mike Pence, Speaker of the House Nancy Pelosi, and other members of Congress. This is my 20th fact. The invasion of the Capitol forced members of Congress and Vice President Pence to flee the building for their safety. And it resulted in the suspension of the congressional count and the certification of the electoral vote for several hours. Mr. Trump watched the attack and invasion on television, including where the insurrectionists were chanting, we heard them in the videos, Mike. While watching the attack and invasion, Mr. Trump tweeted, quote, Mike Pence didn't have the courage to do what should have been done to protect our country and our Constitution. At no time during the several hours of attack and invasion of our capital did then President Trump order any federal law enforcement of the District of Columbia or the District of Columbia National Guard to help retake the Capitol, to protect the Vice President, to protect the members of Congress, or to protect the Congressional Security Police who were attempting to defend the Capitol on many were insurrection. During the attack and invasion, Mr. Trump made no public statement to ask the insurrectionists to cease their illegal activities until over 3 hours after the violence erupted, when, after 3 long and bloody hours, at 4:17 PM on January 6th, finally tweeted to the insurrectionists, quote, "We love you. You're very special. You've seen what happens. You've seen the way others are treated. I know how you feel, but go home and go home in peace," close quote. Let me step aside from the undisputed facts for a minute. Make this observation. Mr. Trump's tweet was a loving call to retreat by a proud general of the insurrection, rather than demand to stand down in the condemnation that one would have expected from the nation's chief executive officer. Back to the undisputed facts. Upon receiving this communication from Mr. Trump on Twitter, and upon its announcement to the members of the crowd, the insurrectionists immediately obeyed. Immediately. On directions from Trump, and saying they were acting on directions from Trump, they ceased their attack of the Capitol and finally withdrew. Last 2 facts. Mr. Trump is a declared candidate for the presidency and seeks to have his name included on the ballot in the Illinois Republican presidential primary election. He's filed a certification stating that he is qualified to serve as president, the inaccuracy of which is the subject of this objection. These 27 undisputed facts, even without recourse to the rest of the very substantial evidentiary record, including the transcript of proceedings from Colorado litigation, factual findings of the January 6th special committee, and more. These 27 are alone a sufficient basis to establish the fact that Donald Trump engaged in an insurrection aimed at disrupting the constitutional election certification process, in violation of his oath of office, and accordingly, under the Constitution and the law of the state of Illinois, Mr. Trump's name should be honored in the primary ballot. Your Honor, as we have detailed in our motion, there's a lot more relevant and materially undisputed facts found by the Colorado court, the Maine Secretary of State, the United States House of Representatives, and apparent on their face from the documents submitted. You've properly presented that, and we urge you to consider all of it in your ruling. But we submit, don't have to go beyond the 27 undisputed facts to grant our motions for summary judgment or judgment. We respectfully urge that you recommend to the Illinois State Board of Elections that it grant our objection, uphold the Constitution of the election, and rule that candidate Trump may not be included on the primary ballot. I'm with my prepared remarks. I want to make one other comment. Like I, sir, have dedicated more than years of our lives to the legal profession. You is the judiciary, me just a work lawyer outside of the judiciary. But what binds us in this profession is the respect for the community. What's that? So I'll find something else to do, or maybe another country to do. That is what's at the center of this case. Who anybody in this room is going to vote for whatever reasons in this upcoming election, that's their business. It's not our business. But it is our business. It is the business before this hearing officer, for this proceeding. The Constitution be obeyed, the rule of law be respected. For if we lose that, it's Katie Barnett. I conclude my remarks unless you have any questions for me at this time. Observe the rest of the time we have for follow. I thank you for your patience and your attention.
All right, thank you very much.
I can just have a moment to add a computer to the podium, Your Honor.
Sure.
Oh, later. Thank you. Hold on one second.
Oh,
I walked away with the mic. I think that's mine. That's yours? In that case, chuck it.
You want me to put this on, and how does this work?
No, you can just leave it on the podium where it was. It's just his mic so we can hear him.
Okay, great. Thank you very much, Your Honor. Thanks for having us today. So my name is Scott Gessler. I represent President Trump here. So the way we're going to structure our argument is I'm going to focus primarily on factual allegations that have been made here. There's lots of disputes. And in fact, we think that the evidence in the record shows clearly that President Trump never engaged in insurrection. Procedurally, one would look at this by looking first at the state law, whether or not there's actually a cause of action in state law. That really should be the first issue. My colleague, Mr. Adam Merrill, is going to address that. The second step normally is to look at the law to determine whether or not Section 3 is even appropriate and whether it applies here. So that would be the second step. And my colleague, Mr. Nelson, is going to address those issues. And then we would get to sort of the factual allegations. That's why I'm here. So we're doing this a little bit in reverse order. But because that was the emphasis of the objector's presentation, we thought we would start in this manner. The objector said there's no sort of complexity exception to Illinois law, and we sort of dispute that. There's a thing called the 14th Amendment, which we're here, and that includes due process. And I would sort of frame this as a general standpoint with respect to these factual allegations. What the objectors are asking you to do, and what they've asked other courts to do, the vast majority of whom have declined to do this, is in a pre-election expedited contest, take an incredibly complex factual and legal set of issues, no live witnesses or very limited witnesses, no discovery, to make a determination about an event that occurred a year and a half, whether there's insurrection or engagement in insurrection, things that are akin to foreign relations, the very existence of government. In Colorado, where I hail from, that's 2,000 miles away from Washington, D.C. Illinois, I think it's about 100 miles away, where there's no discovery, no full exploration of the facts. And what you saw that video, I think, is a very good example of why we should all be thankful we have due process here. And that was a highly curated video. You saw sort of chants of the crowd superimposed over a scene at the Capitol, superimposed over scenes inside the Capitol. You had other things going on with police reports. All of this audio sort of superimposed, volume increased or diminished, uncertain perspectives, and almost none of those scenes actually involved the rally at the Ellipse where President Trump spoke. Of course, there were a couple of clips of him speaking, a lot imposed on violence to try and raise our emotions, to get people angry and say the calculation here is Trump plus violence equals insurrection. That's really sort of the formula they're trying. But this is a nation of laws, like you. We dedicated our lives to trying to make sure that those are faithfully followed. And here, the evidence shows that the limited evidence we have shows that there was no engagement by President Trump in any violence, and that there was no insurrection. And in fact, these standards are so amorphous and malleable as to be unworkable. Now the objectors say, look, everyone agrees this was an insurrection. That is patently not true. So the objectors said the definition of insurrection is obstructing the function of government and the peaceful transfer of power. I defy your honor or anyone else to find any authority where a court of law or even an administrative agency has ever used that definition. Nowhere does it appear. And I will tell you, in Colorado, there's one court in the entire history of the country that has applied the term insurrection to these events, used a different standard. And they relied on experts. There's within the transcripts, which I'm sure you committed to know. There's an expert, Professor Magliata, who argued that this was insurrection. He used a different standard than what the complainants in Colorado used and what the Colorado Supreme Court used. And his was yet a different standard. And this is yet another standard. So I will be straightforward with you. The term insurrection is undefined. There's been elements, President Lincoln in his proclamation said it had to be armed force. The general consensus among academic literature is that insurrection has to be similar to a rebellion and not a riot, but we don't have standards for that. And that's in part why this is a political question, although Mr. Nelson's going to argue political question more, it's because in order for a court to adjudicate these issues, there need to be clear standards. That's one of the hallmarks of law. And there are no clear standards. Congress has not established clear standards at all. And so what happens is the objectors are basically, to be frank, making it up. They're making up a standard that they are trying to discern somewhere within the case law, which has never been explicated in that manner, to fit the facts that they have or that they are trying to assert here. And to the extent the court wants to engage in a level of research that we've had to go through, there are multiple definitions within the literature. There are a few definitions historical around the Civil War period. Well, when the 14th Amendment was enacted, there was little question that there had been a rebellion, an insurrection. That was the context of the drafting of this in 1868, the passage of the 14th Amendment, ratification, drafting 1866, and the ratification in 1868. So I would start from the fact that the definition of what constitutes insurrection is malleable, and that the objectors here are just making it up. And if you actually take them at their word, essentially almost any obstruction or any violence becomes an insurrection. It's a massively broad standard. Or conversely, they may come up with a standard that's so narrow it just happens to fit only these facts ever, but it's still being made up. Let me just talk about some of the facts as I will. And before I jump into general, I want to be respectful. I know Your Honor's been received a lot of pleadings and whatnot. Do you in particular have any priorities of discussion that you'd like me to address? So I want to be as efficient as possible and certainly address your concerns.
Well, I appreciate the question, and no, you may proceed as you plan.
Okay. So let us talk about some of the claimed facts. So one of the claimed facts is that the crowd brutally attacked the police. Now you saw a highly curated video, which is produced by the January 6th Select Committee, which was I'll talk about that in a minute, a very biased organization, where every single member had already voted to impeach President Trump on incitement of engagement. And they used that process as a way to sort of prove out their thesis. And this was the best, the most violence they could come up with. This is the most violence that could ever occur. You just saw it. And that was the montage. They sort of superimposed video over that. There was a lot of scuffling going on. And it sort of gets you angry when you look at that. That was very limited. We provided 2 affidavits in the motion for summary judgment that showed 2 people who saw hundreds of thousands, who listened to tens of thousands, who were at the ellipse, who were at the Capitol, who were at the grounds, who saw incredibly limited amounts of violence, and certainly not an organized mob. If you look at the Colorado transcripts, I would suggest you look carefully at Tom York. I jokingly refer to him as Ishmael, the character from Moby Dick, so a witness of everything. And he attended the rally, and that was first-person evidence, unlike anything that's been provided here. First-person evidence of someone who was actually at the ellipse. And we also produced Ms. Kremer. She testified in Colorado, and that testimony has been admitted. She was the organizer of the rally. And there's a video there, and we're not showing that video because it's really boring. And the reason why it's really boring is there's no violence. There's people milling about. There's people listening to the YMCA song from Village People before President Trump goes on to speak. And then there's people walking and talking to one another. And that's really the main stuff that occurred that day. So to argue that the crowd was some organized, unified mob that really attacked the police is simply a false narrative. I'd also note that in the evidence in Colorado, the testimony, there were 2 police officers out of the entire Capitol Police Force, 2. One of whom testified that he had heard radio transmissions from the gun recovery unit. And he said, well, the gun recovery unit They were talking about people either having weapons or possibly having weapons for later arrests. On cross-examination, he admitted there was not a single person at the Capitol who had a firearm the entire day out of hundreds of thousands of people. Not a single person. There was no armed violence in the sense that we understand it, in use of deadly force. There were people who used makeshift flagpoles and makeshift bike racks. So that's not true. There's an argument that people entered to assassinate President Pence. No evidence of that. There's been no criminal charges. None in the record, none beyond an factual assertion and implication from the January 6th Select Committee. There's an argument that the Capitol was overrun. So there's 3 witnesses, 2 police officers from Colorado, who show that part of it was breached, the Capitol. But if you look at Tom Bjorklund's testimony, he actually testified in many instances the police allowed people to come into the Capitol, and his testimony shows that. So that's a fact that we dispute. There's a number of other arguments, but let's also talk about potential engagement. So the argument is that President Trump engaged in insurrection. And on this, the objectors are in particularly weak ground. So what does engage mean? Well, it does not mean incite. In 1870, Congress passed the Enforcement Act. Actually, I take that back. In 1862, Congress passed the Insurrection Act. And that's still in the successor, still in U.S. statute, 18 U.S.C. 2383. And what it says, it makes it a crime to engage in, to incite, to set foot upon. It uses those words as activities that are illegal, which, by the way, no one has ever been indicted or prosecuted. No one, okay, in the federal law. And that, to engage in, incite, set foot upon, cause insurrection along those lines. So Congress actually used the word engage and incite in 1862. And then about 3 years later, it started drafting the 14th Amendment. And it excluded the terms incite, it excluded the terms set foot upon, and only limited itself to engagement. That itself is very good evidence that engaged is not equal to incite. And engagement does mean, some voluntary assistance and help, which is different than incite, which is to cause other people to do things. And if you look at the evidence that they rely upon, 100% of the evidence they rely upon is public speeches by President Trump, public commentary, a public video from President Trump. It's all public political speech. And so we actually do have a record to be able to look at that in a meaningful way to determine whether or not President Trump engaged in insurrection. And the answer is no, he didn't. So the Nwangumi standards, the Nwangumi case, which derives from the Brandenburg versus Ohio standards, the U.S. Supreme Court talks about the standards for when activity, or speech, I should say, when speech turns into incitement. None of those standards, this was by no means incitement. One of the standards talks about sort of temporal relation. It has to be an immediate thing. And so a lot of the statements, some of them that the objectors rely upon months, sometimes years before, none of which President Trump called for violence in any manner whatsoever. It's hard to say, it's impossible to say. Legally, it's unsupportable. And one cannot say that incited violence. The most they can rely upon is a will be wild tweet. Come to the rally, it will be wild. And that was the Ellipse rally, where there was no violence. Even the objectors recognized there was no violence at all at the Ellipse rally, when and where President Trump spoke. Then we look at the events on January 6th. And the objectors left out a few important things. In fact, I'd say a few critical things. President Trump, at his speech at the rally, said, "I know you will be marching down to the Capitol peacefully and patriotically to make your voices heard." I'm not even sure that's really a call to action to recognize that, but let's call it a call to action. The call to action was to go down to the Capitol and make your voices peacefully and patriotically heard. Peacefully and patriotically heard. Now, the objectors point to one tweet at 2:24 p.m. Now remember, let's look at the timeline here. So the violence at the Capitol starts before President Trump and ends his speech. It starts before he even ends his speech. It starts before he even says, go down to, I know you will go down to the Capitol and march peacefully and patriotic. Violence at the Capitol has already started. And then Trump finishes his speech, or towards the end, he says, I know you'll go down to the Capitol, you'll be marching down peacefully and patriotic. That's what he says. And if you know the Capitol, it's anywhere from about a 20 to 45-minute walk to get from the ellipse to the Capitol building. And in fact, Tom Bjorklund, Mr. Bjorklund, testified that that's about how long it took. In fact, he testified that after hearing President Trump's speech, he wanted to go to the Capitol, but first he and his colleagues had to find a bathroom, which was in short supply. Hardly the activity of someone engaging in insurrection. And in fact, you also see from the affidavits as attached to our motion for summary judgment, or our reply in response to the motion for summary judgment. And this, of course, Mr. Bjorklund's testimony that it was very cold out that day. And so those people looked for warmer clothing in order to be able to, where they went. So the timeline is that the violence begins well before President Trump has even finished speaking, and certainly well before anyone could get down there after his speech. So then people walk down, some people, we don't know how many. And the objectors want you to infer intent that they went down there to be violent. They were unarmed. And every eyewitness account of everyone at the ellipse and walking to the Capitol is that it was peaceful, sometimes described as joyous behavior. In fact, the witnesses in the summary judgment, the affidavits sort of talked about how they were bored at the ellipse speech and then spent about 45 minutes walking down. That's the first event. The violence breaks out at the Capitol well before President Trump has done so. Then what happens is he says, go down there peacefully and patriotically. That's round 115. Then at 2:24, there's a tweet where he says President Trump, Vice President Pence needs to do the right thing. I'm paraphrasing. And then at 2:36, he tweets, support our police, be peaceful. Please be peaceful. That's what he says. And then at about 3:18, he tweets again, be peaceful, stay peaceful. He uses the word be and stay peaceful. He directs people to be peaceful when he finds out this violence is going on. Then at 4:17, he sends out, he puts together a video in which he tells people to be peaceful and to go home. That's a pretty rapid succession of President Trump calling for peace. Now the objectors say, well, as soon as President Trump issued that video at 4:17, everyone dispersed, and that's why they did it. There's no evidence of that. There's just not. In fact, Tom Bjorklund, the only person who even testified that's admissible evidence, said the reason he went home, or he left the Capitol, he went to go sightseeing, is because he received, and his colleagues received, sort of like an Amber Alert, something that pops up on your phone, a text from the mayor of Washington, D.C. at around 4:30 saying go home. So, I mean, the mayor of Washington, D.C. did nothing until 4:30. And that was what, at least the evidence that we've seen, caused people to actually go home. So what you see is a pattern of peaceful behavior by President Trump throughout January 6th. Not once did he urge people to commit. Not once did he urge people to strike. In fact, every communication of his, every communication was peaceful. Now, one of the arguments they make is they say, well, President Trump didn't order the National Guard in soon enough. He was neglectful. There's a substantial amount of case law. We can provide you with that, but look, courts are not in the business of telling presidents how to mobilize and not mobilize armed forces. That comes from the Supreme Court. But what the evidence does show, in the days preceding, and this is from the Colorado transcripts, and I would urge you to look at the testimony of Mr. Koch Patel. He was the civilian oversight for the Department of the Army. And he was in a meeting with President Trump, in which President Trump said, I want to make sure there's 10 to 20,000 National Guards, National Guard troops there in DC. I want to make sure there's peace. We want there to be peace. We don't want there to be violence. And he authorized, he didn't order, but he authorized the use of 10 to 20,000 National Guard troops. Katrina Pearson, she was one of the organizers. She also testified, admitted testimony, that she was in a separate meeting in which President Trump said, I want 10 to 20,000 guard troops. And people said around him, well, hey, we don't need them. We don't think there's gonna be violence. President Trump said, well, if we have that many people, we know there won't be. And at that meeting, and this is sort of the interesting thing, there was also a guy named Max Miller who attended that meeting. And in fact, the petitioners of Colorado, they introduced this into evidence. It was a text that he sent Ms. Pearson right after the meeting saying, thank goodness we killed that National Guard idea. But he recognized that President Trump wanted the National Guard. And how did the Army respond to that? Well, if you look at the Department of Defense IG report, which is in evidence, President Trump followed up and said, is everything going to be okay? And the Army said, we got a plan for that, don't worry. We got a plan. And what you basically see, and then also you see Mayor Bowser, okay, and that's in evidence as well, a letter from her, from the mayor of Washington, D.C., to President Trump saying, essentially, don't you dare give us National Guard troops. There were 346 mobilized for traffic purposes. And the mayor said, that's all we need. We do not want any more. We do not need any more. The Capitol Police have this in hand. You better talk to me before you even think of mobilizing. So what's going on here? President Trump, I think the evidence shows, was the only one in Washington, D.C. who wanted Guards troops there to make sure there wouldn't be violence. And everyone was horrified by his thought of doing that. Why? I don't know entirely why, but I can surmise that Mayor Bowser and members of the Army were fearful of what it would look like having all these Guard troops there. And perhaps Mayor Bowser was afraid that Trump would try to take over government with these troops. And so they all opposed it. And his urging for National Guard troops basically was swallowed up by the bureaucracy. Army said, we have a plan, don't worry about it. One of his staffers said, thank God we killed that idea. The mayor said, don't you dare have National Guard troops here. And Trump is meanwhile, President Trump is consistently saying, I want to have 10 to 20,000 in not one, but 2 meetings validated by 3 witnesses. That's what happened. So there weren't a lot of Guards troops there. But after, if you look at the timeline, initially the Sergeant at Arms in the House and Sergeant at Arms in the Senate did not want to ask for assistance or troops, even as the violence was unfolding. I think that's evidence that shows you that they didn't think this was an insurrection. They didn't want the optics. That's what they said. But eventually they did ask for it. The Guard troops were mobilized and they arrived on scene around 5 or 5:30. Now look, I used to serve in the reserves. National Guard troops do not sit in their barracks with backpacks ready to storm wherever they need to go at a moment's notice. They are men and women, mothers and fathers, sons, daughters, brothers, sisters, who live at home, who work, who have jobs on Tuesday, January 6th. And that's what they do to go about their business. That's why they're part of the reserve component. If they nonetheless were mobilized in about 3 hours, 2.5 to 3 hours, Patel testified to this as well, which is blazingly fast, which shows that at least part of President Trump's authorization was, and that the Guard was pre-positioned to go forward. And that's, I would submit to you, because President Trump authorized that. So, and the Army, although they didn't want to actually mobilize those people. That's what the evidence actually shows, not what these accusations do, unsupported by evidence. Evidence shows President Trump wanted National Guard there as a preventative measure. The evidence shows that on January 6th, he asked for peaceful behavior repetitively and consistently. And you can search every single one of his tweets. You can search every video. Not once does he ever call for violence at the Capitol. He jokes about it a few times years before at rallies. So there's 2 things. There's really sort of 3 things that they rely on. At the end of the day, you boil the evidence down, you lift up the lid and you look down, there's 3 pieces of evidence they really rely on. One is the tweet at 2:24 that says Pence needs to do the right thing. President Trump doesn't say go commit violence. He doesn't say stop the violence. He says Pence needs to do the right thing. That's what they rely on. All right, that's his public statement. That's now called violence. And in fact, it was followed up about 12 minutes later. I believe my numbers are right. I may be off by a minute or 2. 12 minutes later by a call for peace. And it was preceded about an hour before by a call for peace. That's one piece of evidence. And then they look about 3 days before where President Trump says, come down to the Capitol, we'll be wild for the rally. I submit that's a politician trying to drum up support for a rally of his. And will be wild, using normal lexicon, normal English language, as people every day use it, does not mean let us go storm the Capitol and take over government. It's usually used in the context of come to this party, it's gonna be wild. People are gonna have a great time. I've never in my life heard someone say, come to this, it will be wild. And that can mean, let's engage in violent behavior. Never once. I would submit you've probably never heard. And no one has, until President Trump uses the different standard. Trying to impose a different standard. So that's really sort of, they've got those two pieces of evidence. And the last piece of evidence is a joke years before, which he's at a rally in Florida, in the Panhandle. And someone says, I mean, that's a rhetorical question. Someone says, well, let's go shoot him. Advocate violence. President Trump says, well, you can only get away with that in the Panhandle, but nowhere else. That's what he says. People laugh at the joke. He moves on. That's not an endorsement of violence. It's a joke. And if anything, the implication is don't commit violence. It's certainly not a call for violence to overthrow the government. So their evidence, when you look at it, actually falls apart. Very quickly, I've addressed some of this, but let me run through some of the evidence they claim that is undisputed. They talk about how these other speakers engaged in incendiary speech at the ellipse. Well, first of all, I ain't seen evidence of that, and it ain't admitted, and it ain't President Trump's speech. Second, I think if you look at it, even the examples they have, those aren't calls to violence. Third, if you look at Katrina Pearson's testimony, that's testimony, live testimony that heard in the Colorado court. She helped organize this, and what she said was, look, I wanted to keep the crazies out of there. And she specifically mentioned this guy, Alex Jones, I don't know who he is, and a couple others. And she said there was all this, back and forth. And Chief of Staff Mark Meadows told me, make sure to keep these people. And she takes this list of President Trump that has some of those names that some people have been pushing. And President Trump crossed them all out. He even crossed Giuliani's name out. He didn't want Giuliani to speak. Live testimony, someone who was looking at President Trump as he was doing it. President Trump only wanted to have senators and congressmen, and even not only a handful. There was a question as to whether or not his children would be able to speak again, or at the ellipse. Sorry, remember there's an ellipse in this. Yeah, even I shouldn't. And so the purpose was to specifically prevent incendiary speech, and President Trump was part of that effort to prevent that. And in fact, if you look at remember I mentioned that text between Max Miller and Katrina Pearson, the people who were at that meeting with President Trump. When Max Miller says, thank God we killed that guard idea. Well, the other thing they were talking about repeatedly was, boy, it's really good that we kept these incendiary speakers. They didn't use the word incendiary. But if you look through that text string, they say, boy, it's really glad we kept these people off. So there'd be no question that we were trying to urge this type of violence. The context of the conversation was that they had dodged a bullet almost. They were thankful that they had been careful in taking precautions. That was the context that took place. When the objectors say, well, this was an armed and militant group, there's no evidence of firearms, none whatsoever. And in fact, the police officer said that this gun recovery unit was looking for people, and he admitted, and again, there's two police officers that spoke, the only ones who would come forward to sort of cast aspersions on this and try and make these arguments. Even he admitted that there was never any armed people, and there's only one piece of evidence of a knife ever. Someone had a knife on them who never used it, who never unsheathed it, who had been stopped by the police, and then he went on his way and they let him go. Obviously, they weren't that concerned with it. Fight like hell. So we have a video, number 1074. What the objectors want you to do is think that, when President Trump uses the word fight like hell, or the phrase fight like hell, that means go commit violence and overthrow the government. Let me tell you, that is common political discourse, that combative type of language. And it never means violence, or certainly never with Trump, and not others. Can we show video 1074, I believe? And I'm going to wrap up my comments pretty quickly, Your Honor, and allow other people. details.
That cookie's at the bottom that needs to be accepted. So they heat it like there.
Okay, Your Honor, while he's doing that, let me just make a couple more points if I may. Sure. So we, that's fine, be a little bit efficient here. I'd like to just make 2 or 3 additional points. January 6th committee, we have vigorously objected to that from the very beginning. And I don't quite know what the evidentiary standards are at this hearing. Let me argue why you should not accept it. We're certainly reject it. It's a governmental report. It's a government report with very little reliability or trustworthiness. And here's why. It was a committee designed to prove a hypothesis. Every single member of that, Republicans, 2, whom were appointed by a Democrat Speaker of the House, and all the Democrats, it voted for the article of impeachment. The article of impeachment said President Trump incited insurrection. They already voted for that, even before they started the meeting. That was not a universally accepted thing. In Congress, it was almost entirely a partisan vote. 54% of Congress voted for the articles of impeachment. 46 voted against it. I would urge you to take a look at Representative Ken Buck's testimony from Colorado. He was a congressman. He was at the Capitol steps. He's been a prosecutor for 28 years. He was a staff member of the Iran-Contra investigation. So he actually knows what these congressional investigations look like in highly controversial areas. And he said this was akin to him showing up in the court as a prosecutor and the defendant not being there and the defense attorney not being there having a trial. That's what he characterized the January 6th committee proceedings on. Because every single one of the members actually had already voted and already prejudged President Trump on that issue. And they picked and chose their evidence to prove that hypothesis. There's testimony in Colorado, Katrina Pearson's testimony, Patrick Patel's testimony, none of it found its way into the January or the editing process, I would submit. It was very biased to begin with. It was filled with prosecutors, none of whom had any technical experience or any experience in quote insurrection. So you don't have a deference to an experience of governmental entity. In fact, one of the prosecutors there was also the personal attorney for one of the Representative Kinsinger who had voted for impeachment as well. So he sort of wore both hats, obviously with no conflict. This was poisoned from the very start. Congress did take action, and the Senate refused to convict President Trump of the article of impeachment. That itself, I would argue, is evidence of that. So the January 6th report, I would support this poison. submit that as poison. Excuse me one moment, Your Honor. So you didn't receive it, huh? Oh, here it is. Excuse me. Your time. I don't know if this is the correct one, Your Honor, but let's give it a try. I'll stop it if it's not the one I intended.
Our mission is to fight.
Our job is to fight.
We are in a fight. We are in a fight. We are in a fight.
Democrats are fighting as hard as we can.
Democrats are standing up to fight.
We know how to fight. We like a good fight.
Democrats are going to fight like hell.
We fight like hell.
I'm going to fight like hell.
I will fight like hell.
We're gonna fight like hell.
I'm going to fight like hell.
Fight like hell.
I will fight like hell.
We have to fight like hell.
I, and I know many other senators and members of the House, will fight like hell.
We are gonna fight like hell.
We're gonna fight like hell.
Let's fight like hell.
And we just have to fight.
We're gonna fight. We are gonna fight. We're gonna fight. We're gonna fight.
Because you'll fight
To fight.
political revolution. That means that millions have got to stand up and fight. And fight and fight. Stand up and fight back to fight. And continue to fight. Once again, fight back in the fight.
We're fighting back.
My fight. To fight an administration.
You don't get what you don't fight for.
We'll also fight him and challenge him in every way that we can.
Fight in Congress, fight in the courts, fight in the streets.
In the Congress, in the courts, and in the streets.
There's the fight, and then there's the fight to defend.
We're eager to take on this fight.
The American people are going to have to fight.
Get in this fight.
Get in this fight.
Around the clock fighting.
We've got to keep fighting and keep focused.
We will fight when we must fight. We've been fighting, so we need to fight, but we also need to fight.
Always gonna be an uphill fight.
This is going to be a fight.
We always must fight.
We're in the fight of our lives.
We're gonna be in for the fight of our lives.
This is the fight of our life.
Fight of their lives.
We are in this fight for our lives.
We cannot ever give up fighting.
Fight like hell. We're gonna take the fight to the streets. Are these people asking for violence? I see no. What's President Trump? There are common modalities of campaign speech. There are common ways politicians communicate, urge their followers to get riled up for political action. And that's exactly what President Trump is. We are a country of rule of law, and we're a country of democracy. And I would submit that these arguments, and my colleagues are going to address the legal arguments, are an attempt to prevent people from using highly spurious legal theories, potentially untested, without an adequate evidentiary basis to drive home a political point, to prevent President Trump from being able to appear on the ballot and prevent people from Illinois from being able to vote. And in this instance, what I would ask you to do is actually take a closer look at the evidence. Take a look at the evidence, all right. And take a look at, listen to the actual evidence here, arguments we make, rather than these sort of broad, sweeping generalizations. Now, there was violence at the Capitol, there was rioting going on, and no one can tell us that. President Trump did not urge that. He did not engage in it. He didn't engage in movement site. He did not cite. There are a host of other reasons. I'll let my colleagues address those. But in this instance, Your Honor, we ask that you, in making your recommendation, recognize the infirmities of this case and do, frankly, what the vast majority of the country has done. The courts to consider these issues, all except Colorado, from where I am. But everyone else has had the sense that this stuff is just inadequate. There's inadequate jurisdictional grounds. There's inadequate evidentiary grounds. Certainly the jurisdictional issues, the federal issues are going to be decided by the U.S. Supreme Court very soon. There's an oral argument coming up on February 8th on that. But the state of Illinois should not interfere with that electoral process and let it go forward. Thank you very much. Thank you, Mr. Gadsden.
Your Honor, I'd like to address one point of Illinois law, and that is that the electoral election code doesn't authorize the electoral board to delve into the federal constitutional qualifications of presidential candidates. Now, as an administrative agency, the electoral board is a creature of statute, a creature of law. And so the focus really is on what is the electoral board's statutory authority to address this objection. And that statutory authority is contained in section 10-10 of the election code. Now that section grants the electoral board authority with respect to 4 types of objections to nominating petitions. One, whether the nominating petitions are in their proper form. 2, whether they were filed within the time and under the conditions required by law. 3, whether or not they are genuine nomination papers. And 4, in the cases where you have a caucus or a party convention, whether or not the certificate of nomination represents accurately the decision of the caucus or convention. That one is clearly not applicable here. Now, we would submit that those are relatively narrow. And one of the ways you know that those are relatively narrow is by the schedule that is normally set in these types of objection proceedings. You've got a matter of a couple of weeks, limited procedures, limited discovery, relaxed rules of evidence. And I think in this particular instance, the initial call was on January 17th, and in theory, it's going to be resolved next week on the 30th. It's not an amount of time that permits a detailed, fact-intensive investigation into qualifications of a federal candidate. Now, at the end of section 10.10, after it lists those 4 things, there is some language that says, and in general shall decide whether or not the nomination papers on file are valid. Now, the objectors suggest that that gives the electoral board broad authority, but we would submit that that phraseology at the end has to be construed in the context of those 4 types of objections. And if you look at the cases that the objectors have cited, those cases, none of which apply in this type of circumstance, none of which have applied to the examination of the president, of the qualifications, the federal qualifications of a presidential candidate. They're state law issues. In fact, Goodman v. Ward, which Mr. Pierce referenced, there's a quote in there that says the scope of the electoral board's inquiry with respect to nomination papers is ascertaining whether those papers comply with the election code. That's on page 411 of Goodman. That is the inquiry that the electoral board is tasked with here, and the recommendation with respect to which you are making. Now, there are a couple of instances where in the past, there have been a handful of electoral board decisions regarding citizenship of U.S. presidential candidates. Those involved President Barack Obama when he was a candidate, and Marco Rubio as a candidate. And those did address the citizenship. But we would submit that in those cases, and they've been cited for the court, copies of which have been included in the papers that were filed, there's no indication that anyone argued the electoral board lacked authority. And arguably because it was a relatively simple way to get those cases dismissed, and that's what the candidates did. In all those cases, the challenge was dismissed or the objection was overruled. And in any instance, that's not binding authority in Illinois anyway. It's not an appellate court. It's not the Illinois Supreme Court. And those really are not binding authority for the scope of the authority. So we would submit that the electoral board simply lacks the authority to delve into complicated federal constitutional questions that are involved. Right, thank you, Mr. Mayor.
Thank you, Your Honor. Nicholas Nelson. I'll be closing up here.
as Your Honor remarked, as several of us have remarked, we've had a bit of a whirlwind getting here, and Your Honor now has a lot of evidence and a lot of paper for you that was filed in a pretty short period of time. Of course, you have to now sort through it all and figure out what to recommend to the board. I will venture a guess that it has gone through Your Honor's mind to ask whether really delving into all this evidence and making a recommendation of facts so quickly is the optimal way to decide who should be the next president of our country. I would like to map that potential question onto the legal arguments in our motion to dismiss and suggest that it's not. There are a number of reasons why the objection should be dismissed without getting to the merits. Really, you can pick between many different arguments that we've made. All you need to do is pick one. I'd like to sort of map them out, explain their logical order, their logical relationship to each other. And then if Your Honor has one or more that you'd like to focus on, we can discuss that. There's basically four steps, I think, four stages of argument that one would go through. The first is, does the board have authority to take up this kind of dispute at all? The second would be, if the board has authority, is there a cause of action under Section 3 of the 14th Amendment that can be asserted through objection before the board? The third would be, does Section 3 apply to this general type of case, to this general type of claim? And then the fourth would be what Mr. Gessler and the other side have addressed, which is, if all of those things are true, have objectors pleaded or proved the elements of what would be a Section 3 violation here. So to start at the outset, we have two arguments that the board just simply lacks authority to take up a dispute like this. One is the argument under Illinois state law that Mr. Merrill discussed. I won't go into it again here. The second is the political question argument that we've articulated in our briefs. And the short version of this, Your Honor, is that when courts and tribunals throughout the country have been confronted with disputes like this, with claims that someone is not qualified to be the president of the United States, they have very frequently said, the Constitution sets forth a lot of procedures for how we choose who should be the next president. The Constitution explains how and when we do that, and it's not here. It's not in litigation in court. It's not in state agencies. So we just don't have authority to do this sort of thing. We would say that the board should join that pretty strong consensus. As Mr. Merrill mentioned, the board has considered and dismissed a couple of objections in relatively summary fashion in the past. That would be an option here. We certainly wouldn't object to that. But the alternative, instead of diving into a big dispute, would say, well, if there is a question that would really have to be, we'd have to get our hands dirty with here, that would be the kind of political question that these other courts have said, not our job. The Constitution commits this dispute elsewhere, and we would say that the board should do that as well. That's stage one. Does the court have authority, or does the board have authority to take up this question? If it did, we would get to logical stage two, which would be, is there a cause of action that can be asserted under Section 3 by the method of submitting objections to the board? We would say no. 10 months after the 14th Amendment was enacted, the sitting Chief Justice of the United States, Salmon Chase, held that a cause of action under Section 3 has to be authorized by Congress. Congress has to pass a statute saying, here's how you enforce Section 3. No one claims that Congress has authorized this board or an objection in this board to enforce Section 3. That rule that Congress has to authorize this was the unbroken constitutional practice from the time Section 3 was enacted until 2021, until this current wave of Section 6 litigation. In that entire time, no decision maker anywhere, no court, no agency ever did what objectors are asking the board to do now, which is to go off without congressional authorization and hold someone not qualified to hold office pursuant to Section 3. So we don't think that this is the right time for the court to break from that long-established consensus approach. That would take us then to stage 3, right? If the board had authority to take up this dispute, if there were a cause of action available, then the question would be, should Section 3 be interpreted to apply to this kind of dispute? We offer several arguments to why it should not. First, Section 3 bars holding office, not running for office. And we know because almost immediately after the 14th Amendment was enacted, the tradition began of people who were arguably barred by Section 3 running for office, getting elected to office, and then having Congress vote to remove the disability, and they were allowed to take office just fine. No one suggested wait a second, the 14th Amendment should have prevented you from running office, should have prevented you from being on the ballot, should have prevented you from being elected. The people who enacted the 14th Amendment did not think that was a problem. And in fact, more modern case law establishes that the states cannot take a qualification that's created by the Constitution and try to enforce it at an earlier time than the Constitution says they should. This has happened with respect to residency requirements, right? The Constitution says members of Congress have to be residents of the state when they're elected. And the courts have held that that means the state cannot say, well, when you're running for election, when you file your affidavit of candidacy, you have to be a resident here. Not permitted under the Constitution. That's what the objectors are asking the court to do here. The 14th Amendment, Section 3, at most bars people from holding office, not from running for office. That's argument 1 as to why Section 3 should not be considered to apply. Argument 2 would be that the president is not an officer of the United States within the meaning of Section 3. This comes from the exact language that Section 3 uses. So when Section 3 describes who it applies to, there are 2 main elements of it. 1, you have to have been an officer of the United States, and 2, you have to have taken an oath to support the Constitution. Both of those phrases, officer of the United States and oath to support the Constitution, are copied and pasted, if you will, from different provisions of the Constitution that had already been in place when Section 3 was enacted. And every time those phrases appear anywhere else in the Constitution, they obviously, on their face, exclude the president. So, for instance, the phrase officer of the United States comes from the Appointments Clause, among other places. And the Appointments Clause says the president shall appoint all officers of the United States. Obviously does not mean the president there. The phrase oath to support the Constitution of the United States comes from Article 6 of the Constitution. Most people in the government take that oath, but the Constitution is very clear the president does not. There's a different oath in Article 2. It spells it out word for word. The president takes that oath. It does not include the word support. So we think if you just look at the language of the Constitution and the language of Section 3, it's quite clear to a user of English that a person who was writing this would have been meaning to import these terms from the other provisions of the Constitution that do not cover the president. Finally, we have the argument that Section 3 does not apply because it does not bar anyone from holding the presidency. Section 3 prevents people only from holding, quote, office under the United States. Maybe an ellipsis somewhere in that quote, but those are the words, office under the United States. We've explained in our briefs why the constitutional phrase office under the United States can best be interpreted as not including the president. It would be after all of that, if all of those questions were answered, the board does have power, there is a cause of action, Section 3 does apply here despite all those arguments, that one would get to the ultimate factual questions of whether the objectors have pleaded or proved facts that President Trump engaged in insurrection. On that point, I won't repeat what Mr. Gessler said. I would emphasize that there is a legal distinction between a riot or a violent political protest and an insurrection. And I think the key to the distinction, which is touched on in the case law, is that a riot or a political protest may be it may be people who are unhappy with what the government is going to do in one particular case. And it may be people engaging in illegal or violent activity trying to stop or impede the government from doing one particular thing, one particular action. But what makes something an insurrection is it requires more than that. It requires people to be generally revolting against the government's authority or against the authority of a law in general. So I think that legal distinction is important to bear in mind. That would be only if, Your Honor, were to get to the ultimate fact. We've given all these reasons why we think it's not appropriate to do so, and indeed why the board lacked power to do so. That's my overview. If Your Honor has any particular issue you'd like to focus on, I'd be happy to discuss it.
I don't. I think you've been thorough.
Very good. Well, I know we're approaching the end of our hour. I could certainly go into more detail about any of these topics if Your Honor would feel it'd be worthwhile, but otherwise we're happy to close.
That's fine. All right, thank you very much, Mr. Nelson. And this time, as we discussed, we're going to take a short recess. Maybe around 10 minutes.
Since we have to confer with counsel by Zoom, could we get a bit more time to?
How much time do you need?
20? 20 minutes if that's
I said
acceptable.
20 minutes.
We could also
20 minutes is fine.
use the bathroom facilities during that time.
Yeah, I agree. 20 minutes is less. There's only 2 or 3 bathrooms.
Thank you. We'll be expeditious on it.
No, it's fine.
All fine.
reconvene the hearing. And I hope that it's about 12:15. Yeah. And counsel for the objector, are you ready to proceed with the remainder of your argument?
We are, and the remainder of our argument, I think, will not use the remainder of our time, but
That's fine. Mr. Pierce.
it's usually appreciated by.
Yes, there's no requirement that you go to the maximum.
Thank you, counsel, judge. I think we have said in our opening presentation what we want to tell you today, and I only want to very briefly respond to a couple of points made by the candidates. One is this attempt to belittle the violence and to ignore the goal of January 6th. We saw a video clip of numerous, I think all Democratic, but at least mostly Democratic Party politicians using the word fight and sometimes using the phrase fight like hell. And probably every football coach in high school and college in the United States has used that rhetoric with his or her team, and it is in the common language. We don't claim President Trump engaged in insurrection because he swore or because he advocated fighting. We claim, and the evidence shows, that he engaged in an insurrection because he urged, coordinated, facilitated, administered, encouraged, and every other active verb I can think of, a crowd of thousands of people, many of whom he was told that is the reason why he got upset about the metal detectors, because he did not like this. And indeed, in the video clips, they were armed. See anybody pull a gun, but you can beat somebody to death with a flagpole or a bike stand just as well as you can shoot. Law enforcement was injured. But the distinction, what he wanted them to fight like hell for, was completely in violation of the United States Constitution. He had been told so by lawyers, by his own Department of Justice, by Mike Pence, his own vice president. This isn't like advocating to fight like hell for minimum wage increase, or fight like hell for reproductive rights, or fight like hell to prevent reproductive rights, or fight like hell against the minimum wage increase. In this country, in any healthy democracy, we fight, and sometimes we use rhetoric like fight like hell when we wish to impart that we really need to fight with passion and intensity. But when you are the president of the United States and you exhort people to fight like hell to prevent the peaceful transfer of power required by the United States Constitution, you have engaged in rhetoric in a context that is dramatically different from simply isolated snippets of language. That point was completely ignored by Mr. Trump's counsel, and for understandable reasons. It is indefensible. Second, and I want to, there's a decision that came down today. We'll get copies of it to counsel and to the board. In the District of Columbia, United States District Court of the District of Columbia, in the criminal prosecution of one James Little, and the January 5th prosecution. And I just want to read a couple of sentences here regarding the spin on the facts of January 6th. A couple of sentences from Judge Lambert's opinion. He says, and I quote, "I have been dismayed to see distortions and outright falsehoods seep into the public consciousness. I have been shocked to watch some public figures try to rewrite history, claiming rioters behaved, quote, in an orderly fashion, close quote, like ordinary tourists, or martyrizing convicted January 6th defendants as, quote, political prisoners, or even, incredibly, as, quote, hostages. That is all preposterous. But the court fears that such destructive, misguided rhetoric could presage further damage to our country. Your Honor, the parties have given you a very healthy factual record. We ask that you look at it. Take your own interpretation and recommendations to the board as to how much characterization of what happened on January 6th is more accurate. I submit to you, this was a call to violence, response to the call to violence, and violence which attacked the very heart of this democracy. We value so much, we all are privileged. Second, question of whether the board has authority to hear this case has been answered. It was answered by the board, who counsel was incorrect in prior litigation, including in the Marco Rubio case. The board's authority was challenged, and the board determined that it had authority to make a determination that Marco Rubio was not disqualified under the Constitution from running for president. I think that was a national origin, place of birth challenge. That was an issue. But the board is the board, and the board does its best to comply with its statutory authority. But the board and every other legal body in the state of Illinois has one overall loss in the state, and it's the Supreme Court. In our democracy, in this sovereign, we obey the rulings of the Supreme Court just like we do in our nation. And the Supreme Court in good could not have made it any clearer that not only does the board have the authority, sir, it has the obligation. And Ward, Goodman v. Ward, was a case involving false certification of qualifications to hold the office that the candidate was running. So, and what was required by the Illinois Supreme Court is that in the context of such a case, just as we have now, must apply the Constitution in making your determinations. So, don't take it from me. Take it from the justices that oversee all of what we do. The question of authority is completely different. With that, sir, I can only say the parties have, again, commend opposing counsel. I mean, both sides did a remarkable job getting it. I'm proud to be a part of it. I'm proud to be in a profession where we were able to do so with such goodwill and professionalism as we've done. But the paper is there. It doesn't spin lawyers are putting on pages and pages of paper, record testimony from multiple proceedings that will give you the facts that you need necessary to make your recommendation. I urge you, spend no more time with us lawyers. Get into the record here, and I wish you Godspeed and best of luck.
All right, thank you, Mr. Pierce.
Thank you, sir.
Yeah, I do want to comment on the evidence. Obviously, well, commented on it. I will say this, that I will not be announcing a decision at this today. But before I go any further, is there anything else that we need to address today before we adjourn?
Your Honor, we do have original affidavits for the affidavits that were submitted in copy form. So we have those to submit. As a minor point.
Just substitution of the original for what was filed as copy.
That's fine. I'm going to allow you to do that. I mean, if you want to present that to me now, that's fine.
Sure.
These are original affidavits.
They're original signed affidavits.
Your Honor, could we huddle just for a moment among ourselves here?
Yeah, sure. All right, we'll show that these original affidavits, I will substitute now for the copies previously operated.
Your Honor, to the extent we need to, there were three affidavits that we attached to our summary judgment response. And to the extent necessary, we would just ask for the court to admit those. I think that typically that's part of the summary judgment record. There's no need to make a separate finding that those are admitted, but we just need to make sure that the tribunal is gonna.
Yeah, I'll admit those.
Yeah.
I don't know if you need to describe them in any more details.
There were two factual affidavits and then one ending with the affidavit. They were exhibits to our response to the motion, our summary judgment.
Okay, those exhibits are admitted.
Okay. And then the only other thing that we wanted to just remind Your Honor is that we objected to a number in our response to motion for summary judgment. We made a number of objections to various exhibits that are in the record. There's a number with respect to which we conceded authenticity only, but then preserved all other objections. And then there was the testimony in Colorado. We have stipulated that constitutes former testimony under the hearsay rules to the extent that that's, but preserved all other objections. So we just want to make it clear that we didn't stipulate to the admissibility of any of the really exhibits.
Right.
But we did make those stipulations to the extent that that's helpful to the Tribune.
No, and I appreciate you bringing that up, Mr. Merrill, because I do, there was an agreed stipulation order on the exhibits presented. And so I'm going to, I have your attorney's signatures on that, and I'm going to go ahead and sign that as well. All right, so we'll show that agreed stipulation as exhibits is admitted and made part of the record.
Your Honor, I'm sorry.
Yes, go ahead.
A couple of points. One is that there is a fairly extensive amount of objection to evidence. They have been prepared in charts for your consideration as to what ultimately should be in the record and what should not be. But I do want to say with regard to the 191 affidavit, which is an affidavit that is signed by one of Trump's campaign committee counsel, Trump's campaign committee counsel. As we have explained in our proceedings, it's totally improper under Illinois law. It's an improper and invalid 191 affidavit. We have no problem with you reading the affidavit and making a determination, but we do want to note for the record that we have presented quite clear authority that it's an improper 191 affidavit and should not be considered. So read it, but please also consider your objections.
All right.
Thank you.
All right, I think the position is clear. You read it, but ignore it. It's perhaps the okay. Well, at this point, procedurally, there has been a great deal of evidence presented prior to today's arguments. The both sides filed motions, and the objector a motion for summary judgment, the candidate a motion to dismiss, and both sides had an opportunity to respond to the opposing side's motions, and also to then reply as well to the briefs in opposition. So their motions have been going back and forth during this week. And some of these motions are 80 pages, 100 pages long. We're both myself and Alex, my clerk, have been doing our best to keep up with the flow of paperwork coming into us. And certainly the paperwork is not limited to the motions. I mean, we admitted, maybe subject to the objections stated in the stipulation on exhibits, have been a large volume of paperwork. We have the entire transcript of the Colorado 5-day hearing. That's several hundred pages. And I guess, Mr. Gessler, you were the counsel in that case, right?
Yes, Your Honor. I want to welcome you to our pain. Perhaps you have a due process claim. Yes, we understand.
But Mr. Gessler was counsel for the candidate in the Colorado case, in which ultimately the Colorado Supreme Court held that the candidate Trump's name should be struck from the ballot, although it remains on the ballot, I guess, pending the Supreme Court decision.
Yes, sir, that's been stated.
The January 6th report has been admitted for my consideration. That's 800 pages. So well in the neighborhood of 2,000 to 3,000 pages have been submitted by counsel for consideration at this hearing by myself, with the help, of course, of Alex, my clerk. It's my responsibility now as the hearing officer for the board to arrive at an opinion and to as to ruling on the various motions that have been filed, and ultimately to make recommendations to the board as to how those motions should be ruled on by the board, and as to the evidence presented to make a recommendation to the board. My written ruling will go to the board this weekend, and it will actually go to the general counsel, and then will be certainly become part of the recommendation made by the general counsel at the hearing of the state board on January 30th. So I'm prepared to, at this time, adjourn the hearing. And as I've said many times, as a trial judge, to take the matter under advisement. But I do want to comment on the work that I've seen done by the attorneys. Certainly, I would follow up and agree with Mr. Pierce that there's been a lack of rancor. There's been collegiality among the attorneys. So it has been an honor to serve as a hearing officer with really such a high quality of counsel on both sides. The briefs have been exemplary, and certainly the arguments today made by both sides have been of the highest quality. And so I commend the attorneys on both sides. And at this time, the hearing will be.
Your Honor, may I just mention one thing, just because we're on the record?
Yes.
And I think in connection, when you mentioned the January 6th report a few minutes ago, you used the word admitted. And I believe perhaps we would ask for a clarification that it was submitted to you for your consideration, but that you had not yet made a determination as to admission into evidence or not, I'm presuming.
Yes, okay, I understand your point. I've read it, and I'm certainly going to consider it. Subject to any objections you've made, I will be considering it.
Thank you.
All right, thank you.
Thank you, sir.
All right, so with that, the hearing is adjourned. Thank you very much.
Thank you.
Best wishes. Thanks.